So, Bharati, if you thank you very much for taking part in the symposium. And if you just want to introduce yourself and then please continue with your presentation.
Yeah, thank you, Mediator Vikram, first for giving me this wonderful opportunity. And I think it's the first time I'm speaking in an international forum of this kind on mediation. Now, coming to speak about myself, I'm an academic and a teacher in the university, and I've been trying to promote mediation in the education sector in the last few years. I'm also one of the first who has trained in the Singapore Mediation Center, and I'm also on the panel of Singh. So that's about myself. I'm also a trained counselor, and I've been working in a bank, a nationalized bank in India for almost 20 years. So the topic for today is mediation seen in India in the era of Singapore Convention on Mediation. In the last couple of years, there is a lot much more of awareness about mediation and curiosity as well in India. That is compared to before. This is possibly because of the signing of the Singapore Convention on Mediation, in which India was one of the signatories. Now, this convention, just let's go through it briefly. This is a convention that has given recognition and acceptance to mediation as a method for resolving problems after the Pound Conference, wherein Professor Sanders introduced this concept. Now, the purview of this convention is restricted to cross-border disputes. Then why is it that we are giving so much of importance to this convention? This is because many of us countries are expecting that just like the Singapore Convention on Mediation, which has paved way for mediation for dispute resolving in cross-border disputes, similarly, it is expected and hoped that mediation will be an accepted form even within the country on the domestic scene. So the format for today will be a few initiatives, many in fact, that have been taken in the last couple of years in India. Then we'll have a brief overview of what the Singapore Convention has offered. After that, we'll see if any of these features can be integrated into the Mediation Act, for which the Supreme Court Committee on Mediation was put in place by the Indian government and the Supreme Court of India in order to facilitate the putting in place of the Mediation Act and its enforcement. Now, it's not as if all of us do not know about the Singapore Convention, but still, just let's go through a few important features, the salient features that stand out in this convention. We also had other conventions before this, like for instance, we had the New York Convention, which gave recognition to arbitration as an ADR method. And then we had the Ankitral, which brought about harmonization and unification In this way, a voice was given to the developing countries so that their voice was heard. Then rules were also formed and implemented. After this, the Singapore Convention was put in place. The important contribution is through the Singapore Convention is the introduction of a new instrument, a legal instrument, that is the International Mediated Settlement Agreement with unparalleled power. So this ensures expedited enforcement, something that is not possible in any other form of dispute resolution. So this is one of the outstanding features of this Singapore Convention, what it has contributed in the field of ADR. Now, we've already stated that the scope is cross-border disputes. It doesn't cover family or household disputes, inheritance, or employment law. Now, this is a brief statement of what international and cross-border covers. International can be any two parties that have reached a settlement agreement, and these countries can be in two separate states, or in case they are in the same state, even then it can be considered an international settlement agreement if the business is being conducted in another state. Another important clause or statute is it's not required that the place in which enforcement is to be conducted should be in the place where the agreement has been concluded. So all these people, whoever is involved in a cross-border dispute, they can be the users, like sole proprietors, MNCs, corporations, anyone who is involved in a cross-border dispute can be using this convention. Now, other thing is the settlement agreements which have been covered as arbitral award or concluded during proceedings of a court, they are not covered under the Singapore Convention on Mediation. Now, here are a few distinguishing features of the SCM. Please keep in mind that this convention was put in place much before the COVID started in March of 2020, and when online dispute resolution became a norm once the COVID started. This convention and treaty was signed in August of 2019, and it conceived of many clauses and statutes which facilitated online dispute resolution. And then, as in the other cases of mediation, there's a lot more flexibility that is involved, and whatever be the gateway in which the parties enter into mediation, there is no restriction. Another important contribution or statute of the Singapore Convention is that it has delocalized mediation. Just a moment, 1 minute.
Giovanni, any comment up till now?
Coffee was good, and the topic is interesting, so it's okay.
Yeah, I'm sorry for the sound coming from my end. Yeah. Another important statute is the delocalization of mediation, which is the basic tenet of mediation. That is, the mediation process can be done at any time and any place. Now, again, this was conceived at a time when online dispute resolution was not the norm. So that is the significant contribution of the SCM. So it has made the dispute resolution process that much more easy because of these two statutes and clauses. Now, for this settlement agreement to be implemented, it can also be in writing and online. Now, in writing clause in the SCM includes any form of electronic communication also. Something like this was not covered in other forms of dispute resolution, for instance, in arbitration. Now, this electronic means of communication included SMS texts or emails and so on. Whatever be the information that can be recorded through electronic means, and if it can be retrieved at a future point in time or whenever required, it comes under the purview of in writing under the SCM. So this again was a very important contribution. The mediation process, it was not required to be concluded in one go in a single document, and it could be ad hoc, and mediums like Skype and Zoom, internet, all of these, AnyDesk, they were also allowed in the process of electronic communication. Another contribution was the institutionalization of the mediation platforms. Now, these platforms allowed for the back and forth between the two disputing parties and the mediators to be done then and there without waiting for responses, as in the case of emails, SMS texts, and so on. So the documents could be changed, altered, or corrected then and there. And each platform had its own set of rules. Sometimes mediators could be in-house or from outside. Now, as to the enforceability of the settlement agreement, which I have stated is one of the most important contributions of the SCM, the signatory countries went to the extent of changing the laws on recognition and enforcement of the outcomes, and they were expected to expand the number and nature of legal instruments and to modify their own laws and rules of civil or court procedure. So this is a Himalayan, or in the context Himalayan, in the Indian context Himalayan, we can say it is a Herculean contribution. So if a country is changing, a signatory country is modifying its own laws and rules of civil or court procedure in order to honor the terms of the SCM, this is indeed a major and very big contribution. Now, another aspect is that what are the rights or privileges too that the parties to the dispute have in the context of international mediated settlement agreement. Now, the two parties can use the settlement agreement like a sword against a sword. They can attach the assets or property of the dishonoring party to the extent that dishonor has occurred. Now, this single statute gives immense power to the Singapore Convention in that there is a kind of assurance and predictability and certainty that the settlement agreement will be taken forward by the two parties. Such a provision is non-existent in any other form of dispute resolution. Now, the mediation is flexible. This is, of course, one of the tenets of mediation, whether the SCM is introduced or not introduced. Now, in the case of, just let's go through it briefly. Mediation allows for discussion on the mediation platform. Any issues, even not related to the dispute, or if the issues have not in any way triggered or started the dispute. Any issue which is of importance or interest to the parties can be discussed on the mediation table, whether it impacts the resolution process directly or indirectly. Like, for instance, here, there is this person, this young lady, who's having a business. She's a florist, and she has business dealings with this person over here. And then there has been a dispute with this brother in the last 6-8 months. This is because she runs a florist business in a place, staying where they shared the accommodation with their father. And after the death of the father, the brother says, I have a share in the business profits and so on. So here, there can be a number of undertones or layers to the dispute. It's not only about the money. It's possible that there are more emotional undertones in this dispute because it's the case of two warring siblings. So the dispute can be expanded. The settlement agreement can be expanded much beyond the purview of settlement agreement that is possible in other forms of dispute resolution. Now, as per the Singapore Convention, there is no restriction on pathways to entry. It can be through court information sessions or mandatory and voluntary referrals by courts and referrals by other competent authorities. And also, in order to encourage mediation, cost sanctions can also be put in place, and there are also can be legislation. Now, coming to delocalization, which was the punch of mediation in that it was not required that the process be localized to a particular place. The place where the enforcement could be carried out could be different from the place where the settlement agreement was concluded or put in place. Also, the rules and laws of domestic mediation can or cannot be applied for the signatory countries. And designing of the solutions is not restricted and specified to a particular legal system. Now, coming to the post-COVID scenario, with online dispute resolution, which has become the norm, the punch of delocalization has reduced. However, even now, the difference that is accepted between the place where the settlement agreement is concluded and where it can be enforced, acceptability of this particular statute makes this convention important. Now, coming to the challenges of putting in place and implementing the Mediation Act in India. What are the issues or in the terms of the Singapore Convention, which can be challenges or obstacles in taking the mediation process of mediation forward in the domestic scene? Let's go through each of the features that I have spoken about. First is the online mediation, and 1 minute. Yeah. So these are the challenges of putting mediation online in India, in that there's not much awareness of amongst parties, and encouragement and permission by the courts may be possible, may not be possible. And also in the courts, the awareness of scope of the Singapore Convention may be there or may not be there. And also there is a requirement for putting in place more platforms for conducting the online mediations. And in one of the talks, what I came across was there was a course on integrating tech with online support and mediation, conduct of mediation. So these are some of the problems that could be faced in case of online mediation if it is conducted in India. Now, coming to enforcement, feasibility of implementing the settlement agreement in writing. As a country, if the disputes are major and business related and institutional or organizational, there is a possibility that the implementation of settlement agreements in writing is possible, and it can also be made, mediation can also be made mandatory. However, as a country, the enforcement of a mediation settlement, wherein a settlement agreement is put in place in writing, may not work out in a country like India. There's no guarantee or assurance that the disputing parties will honor this settlement agreement. And as to the flexibility, this is because of a cultural perspective, wherein, you know, the families are important, our culture is important, and how do you follow up on the enforcement of the settlement agreement at personal level? So these are some of the challenges in case the features of the Singapore Convention are integrated into the Mediation Act. Now, coming to the flexibility area, that is also a provision in the Singapore Convention. This is a very acceptable and attractive feature which can be integrated in the Mediation Act in India. For this, again, the areas of expertise and required qualification and experience in human relations related subjects and basic knowledge of how mediation is to be conducted, and sometimes where required, qualifications and experience in law. Any of these, a combination of these, would assist in the flexibility in the approach towards mediation and how the dispute resolution is taken forward. So this also covers areas like improvement in communication, addressing of emotional undertones or the true reason of the conflict, which can be possible through expertise and qualifications and experience in human relations related areas. Coming to the gateways, we have seen that there are a number of accepted gateways to mediation as per the Singapore Convention. It could be through court sessions or mandatory referrals, either by courts or through other referring agencies or through legislations and cost sanctions. Here again, this is of course my very personal view. This gateways to mediation can be an accepted method, the gateways that I have mentioned, in case of disputes wherein institutions or organizations are into the dispute. At a personal or individual level, I do not see that mandatory mediation or these cost sanctions will encourage the parties to get into mediation. The reason for this is, in the Indian context presently, mediation is mostly court annexed. And for a disputing party to understand and know about the subtleties of the difference between various methods of dispute resolution, like for instance, between arbitration or mediation, any of these, the parties may not be very much in favor of getting into court or outside, be it just to know about mediation. And it also happens that in most cases, laws are framed in such a way in India that it is the judiciary that gets to be certified as mediators, and conduct of trainings is again for the legal professionals. So people would like to settle their own disputes at their level without running to courts, which is one of the, I was conducting an awareness program for teachers and people across the road. And when I stated that this program is for resolving of problems and disputes, the first thing that was stated was that they do not want to come to such a program. I had to make it attractive to tell them that mediation as a method can be used across the table, even at grassroots level, for solving simple family problems or landlord dispute problems or neighborhood issues or even insurance-based, or in case they are going on a tour in a package tour, and if the tour terms of the tour are not honored, then a settlement is possible through the process of mediation. Now, in all these cases that I have stated, there is no written agreement, settlement agreement involved. It's more the case of the people involved understanding the reasons or issues that are involved in the process of, in the course of the fight or the dispute, and their desire to resolve the dispute. So this is the punch and the most important feature that we need to take across to people. Once we say there is a settlement agreement that is to be signed, and people have to adhere to the settlement agreement, in the Indian context, at individual level, the man on the road will not be attracted to the provisions of the Mediation Act. Even otherwise, we have our own forms of community mediation. Like, for instance, we already have the Panchayat Raj system, wherein the wise elders or community leaders, they provide advice to the people. This is an accepted form of self-government in India. And we also have the Lok Adalat system. So then the issue comes up, when we are having these two, the Panchayat Raj and Lok Adalat, why do we need a new form of dispute resolution? So it needs that much more of convincing people and taking people along. Now, coming to the last salient feature that I had spoken about in the Singapore Convention, the delocalization. Now, in the context of India, given the state-center tussle, again, there has to be a clear policy on the SCM provides for the settlement to take in one state, and enforcement can be done in another state. So, is this provision valid and acceptable in such a way that the settlement be concluded in one state within the country and enforcement is possible in another country? Settlement is concluded in one state and enforcement in another state or across the country? And is there a possibility of the center and state tussle in the enforcement and implementation of the Mediation Act and the settlement agreements? And also within the states, there is a possibility of a tussle. Therefore, at the point of integrating the feature of delocalization in our Mediation Act, a lot of thought has to be put in this particular perspective or clause of mediation. Other than this, in India, we have so many languages. And also, how is it that we are going to communicate as mediators? So other than just the training in mediation, we will have to get across to people, first at the level of training, and second at the level of communicating with the people. It's sometimes not possible for mediators to be knowing that language, and then we would require translators, interpreters, and so on. Then again, the translators, there could be a possibility of miscommunication between the amongst the translators, interpreters, and so on. Of course, this is not expected, but then, it makes the dispute resolution process that much more difficult if you formalize it. That's the reason we need to have mediators at grassroots level, or those who are within the reach of access of people. The major disputes, it's okay to have in different languages. In most of the cases, the major disputes are put in place in English, in which most of the mediators are trained. Then in this context, I would like to share that there was a case wherein a World Bank mediator who was working as an ombudsman in the World Bank, he had to manage communication with the help of so many different families, so many cultures, families, with the help of translators and interpreters, which made the process of mediation indeed not very easy. This was, I'd not like to mention the place or whatever in confidence. Next is the difference in cultures. Like, for instance, mediation as a process was introduced in the United States, and it has become an integral part of, I assume, it has become an integral part of their problem-solving method because of the way in which they are functioning. Like, for instance, I hear Susan Guthrie, I think, she conducts periodically podcasts on divorce-related issues. And we also have child custody battles, stay arrangement battles, disputes going on over there. And then we also have in certain countries in the world, let's say in the US or Canada, if the dog is barking or across the fence, then there is a case on mediation. Now, in our culture in India, most of these cases are solved within the house or within the community. If not by the Panchayat Raj, we need to equip the people at the grassroots level or the servicing community leaders to assist people in resolving the problems without going to a formal method of dispute resolution involving a settlement agreement. Also, the way our society functions is, it's not very much rule-based. Like, for instance, let me give you a very basic example. Like, for instance, in the United States, the driving test involves giving a written test. I think this is on the computer, and then going through the test and knowing the rules on hand. Whereas here, it's more hands-on. And if the rules are not followed, then a case is immediately lodged. In India, it's more hands-on, and a possibility of a written settlement agreement being enforced in the context of India may or may not be possible. Now, the other thing is, the lack or less of awareness amongst the users, the public. Agreed, we are going to put the Mediation Act in place, We are going to have more mediators and more people trained in mediation. We are going to equip our students, the citizens of tomorrow, in mediation. But what about the users? Without the users being aware of this method, it is a kind of stifling scenario for the profession of mediation and for mediators. It has to be cyclic in that the services of the mediators be used by the users. For this, they need to be aware, and within their access, it has to be a convenient form of resolving their small everyday life problems. This is imperative and extremely important in the Indian context. Now, the next is the approach to mediation. There is no clarity, and different models of mediation, I expect or think, are being used by different mediators. At the point when a common policy is being put in place, there has to be clarity on what is the model that we are going to take forward. Now, the next part is the job or job openings or opportunities. Here are a few tussles that are possible. First is the mediators with law qualifications and mediators without the law qualifications. Then we have mediators with human relations subjects and experience, and mediators without the human relations subjects related qualifications and experience. Similarly, a tussle between mediators with work experience and mediators without work experience. Then there is a possibility of mediators in different languages, again in geometric proportions, the problems involved with translators and interpreters. And all of these in combination, we have to give a lot of thought to all these areas at the point of putting in place a policy for mediation and in the Mediation Act. This is given that we are giving so much of encouragement to the citizens of tomorrow, the students, to take up mediation. Like for instance, the Bar Council of India last year, it has made the study of mediation mandatory in India. A new course on conflict resolution and mediation was introduced for the first time last year in India. We have no less than the Chief Justice of India signing an MOU that with the Singapore and speaking of mission launch. And then we also having agencies or offices, like for instance, the Hyderabad Arbitration Center. We also had the virtual summer school. And then there's so much of discussion, but everything is within the ambit of mediators. The panel discussions happen within the ambit of mediators. For instance, we have the Tamil Nadu mediation community leaders interviews. Then we have the Madhyam, which is another medium wherein there are discussions on issues relating to mediation. And here again, we have the Mediator Vikram YouTube channel. Now, all of these is fine. We are taking mediation to the students. And when we are promising them something a few years from now, it is important to keep in mind, how is it that they will be able to put their learning or experience that they have gained in the course of education into practice. So this requires some amount of forethought and thinking about the future of mediation. In this context, I go around and telling students and advocating mediation, but this comes from my heart. Then there is also the case of no recognition of fee or payment for mediators or people who already know mediation without having the certification and at grassroots level. Now, this again touches on the economy or generating of funds. Then again, other areas or challenges are the rural, semi-urban, urban divide in creating awareness. We still have the Panchayat Raj and Lok Adalats quite accepted even today in the context of rural dispute resolution. A Panchayat Raj president, even today, is a very much coveted post in the rural areas. In this context, it is good to take the awareness of mediation to the rural scenario, but it will need a lot of convincing on the part of the policymakers, government, and so on to use this beautiful method. Now, as to the urban context, we do not have many Panchayat Raj systems, and people, by the time we have come to the urban scenario, we want this aspect of confidentiality and taking the mediation process forward and deciding our own solutions. These are the two very important aspects of mediation. As urban dwellers, these two features are extremely attractive to most of us, people living in the urban scenario. Maybe that is why in a few countries, like for instance, I was going through a talk session in which there was talk about mediation centers being established in particular soil. Yeah, in various district areas, and people coming to these mediation centers to resolve these disputes or problems. Maybe we need to have a norm, something like that, to be put in place within India. And I've already spoken about, acceptance of mediation and need for education of the social workers and the legal professionals in the Lok Adalat. As per a Lok Adalat form of mediation, which is an accepted form of mediation in India, accepted form of self-government in India, we have social workers assisting the legal professionals in the resolution of disputes. Maybe it's required to and possible to equip the social workers with training and knowledge in mediation in order to have better functioning and reach of the Lok Adalats. This is just one of the ideas that came to my mind. Now, the last is about the framework for implementation of mediation in India. As already stated, the written settlement agreement and going through the process of a structured mediation in the ambit of courts may not be very attractive to most people in India even today. unless the issue is so big, people do not want to go to court. People do not want to go around the legal professionals for this. So it is maybe a good idea of thinking of assessment, conceiving of assessment and training programs for senior functionaries, so that this could be used in the phase of in the conclusion and settlement of institutional and organizational disputes. Then we could have a second layer with simple awareness diploma program, like for instance, in case association president of a housing complex, he wants to know how to resolve the problem of the various residents in the apartment complex, then he knows how to go about it without having the assessment training or the training to be a mediator. This is also because in the context of India, we still have this respect for elders and wise men. All these things, our culture still allows for that. The headmen in the family even today get that much more of extra leverage. So an assessment program, and it also involves that much more of expenditure, and expenditure both of money, time, effort, which many people may not be having, or they may not be willing to invest. So these are some of the areas. And then basic awareness programs, even for women in the house, how to resolve the house issues. In case there's a tussle between, a student is handling issues in the class, they're having fights in the class. Instead of just saying, yeah, leave it. If the teacher is equipped or aware of this process, she can assist and teach the students how to resolve the small everyday life problems, like a pencil box that is stolen by one student from another student, or inability to reschedule their classes. All these are small everyday problems that do not require a settlement agreement in writing or following it. So maybe a 3-tier system may be a good idea. So yeah, now integrating SCM into Mediation Act. The problems associated with online I've already spoken about, and relevance of the Singapore Convention. Yeah, Mediator Vikram, just 5 to 10 minutes. Can I speak?
No, as much as you want. Totally your situation. You can play as much.
Yeah. Now, the relevance of the Singapore Convention on Mediation in the dispute scene in India. The tenets of the SCM can be integrated in mediation by and for institutions and organizations in almost all formalized structures. Like for instance, in banking, insurance, tourism, hospitality, medical, police, tax officials at senior levels, lawyers, particularly senior lawyers, human resource professionals at senior levels with deciding power, and heads of institutions and organizations. That is, wherever cross-border interface is there or possible. And also, when you're integrating some of these features, then wherever there is a scope for using mediation, even within the country, then the features of the Singapore Convention that are attractive and usable in the purview of Mediation Act. These can be included when mediation is being used by institutions and organizations. This is the way forward to encourage mediation in the context of India and in ensuring that the written settlement agreement be enforced, which is a very important clause in the SCM, in ensuring the enforcement of written settlement agreements in the context of India. We can take it to institutions and organizations. Now, for this, what is the way forward? It is suggested that we have a mediation body headed by a chairman reporting to, these are all my personal ideas, mediation body headed by chairman reporting to the Chief Justice of India. Then a common mediation policy be put in place with a working group. We also have a 5-year mediation plan. We also have opening up of mediation centers and institutionalized mediation platforms, and then putting in place the rules and norms. And not less important is the publicity aspect. Taking all these initiatives to the press, TV, and social media, podcasts, and even at rural level and semi-urban level. We have even today street plays, theater workshops, and burakathas. I worked in a village scenario, and through experience, I tell you that despite the TV and social media entering the village scenario, even today, the children play on the road, and means like the street plays, theater workshops, they go a long way in propagating a new idea, and these can be used in the mediation movement to spread mediation, the awareness of mediation in India. Secondly, the information about pro bono services to be publicized. Then memorandum of understandings could be signed with public institutions and organizations, like for instance, banks, MSME, insurance, hospitality, tourism, education, UPSC and UGC, municipalities, corporations, industrial zones, and so on. Now, once a memorandum of understanding is signed at that level, automatically there is an effort to spread the mediation as a dispute resolution method. It kind of percolates down. Effort is taken at the highest level. Now, again, it's a question of funding of these initiatives. There is a scope for tie-ups and collaborations, memorandum of understandings with Rotary, Alliance, Red Cross, and we also have a certain percentage that is to be invested in corporate social responsibility in wing of business as per, I think, some act, the CSR. I'm not aware of which act it is, but a certain percentage of the business earnings are to be invested in corporate social responsibility in India. So all of these, the CSR initiative could be used in setting up and of mediation centers and training centers, spread of mediation, and all of the activities wherein mediation can be taken forward. Also, in the case of Consumer Act forums, when the Consumer Act is put in place, assistance can be provided. And also international presence and cooperation. Now, as to the mediators, we can have an association of mediators and continuing membership, continual professional development, networking, annual conferences, periodic meetings at regional levels, and can we have international festival? Maybe. And another very important requirement is for a website in public space on pool of mediators, giving their area of specialization and their contact. This again needs to be given wide publicity. This again opens up opportunities for many mediators. Then as to the support services, opening up of spaces, personnel and facilities in all courts, Panchayat Raj and Lok Adalat for mediation. And to encourage mediation, we could also have court information sessions, mandatory and voluntary referral and cost sanctions for people who are already going to court or willing to go to court in the case of major disputes or when institutions are involved or whatever it is, if there is willingness to go to court. And also jobs would come up for translators, specialized translators and interpreters and support staff. Like for instance, I had stated about a 1-year training program for tech support in the case of mediation process. So once a student or someone does a course of that kind, there is more scope and chance that he will be getting an opportunity to be recruited as a support staff in the mediation process, in the case of, let us say, online mediations or in mediation platforms and so on. And also there is a requirement of ethics committee, given that issues of confidentiality are very much important in the purview of mediation. We need to have ombudsman and a newsletter within the ambit of mediators. Now coming to what can be done in the field of education, we could have short courses, a 10 to 12 hour course, a certificate course on awareness, which is certified by the University Grants Commission. Many heads of institutions have expressed a need for a method like mediation to be taken to the students. However, they are not able to get enrollment to these courses because these courses do not have the University Grants Commission in India, which is a statutory body in India for the recognition and validation of courses. Now, once we have this kind of University Grants Commission validation, we are already having the STAR scheme, which is already being put in place in undergraduate level, wherein students are being skilled and trained for jobs. And if they are also trained in mediation in the STAR scheme, it will go a long way. And other than this, Girl Guides, Boy Scouts, school and college teachers, and Panchayat Raj Lok Adalat social workers could be going through this program. This has to be subsidized and, if possible, made online. Then a free 12-hour online course for everyone. Like, for instance, doctors, engineers, teachers, any user who wants to know about mediation. Like, for instance, I had stated about the dispute within the fight amongst neighbors, fight within the community, I mean the residents in an apartment complex, wherein the president of the society has to resolve the problem. So such people, or for instance, in the case of package store, whoever is interested in knowing about this, a free online course is recommended, and an introductory course on mediation and the SCM to be made mandatory in all business schools and schools of foreign business, and crafting of guidelines in assessment courses requiring basic human relations related subjects along with law and experience. Consumer forums, the guidelines can be set by the working committee. Then, as to taking it to the children, there is a collaboration possible with the United Nations International Children's Education Fund. Then there is possibility of simulated mediation body, mediation parliament, inter-university competitions in mediation within India. These days, we have many competitions on mediation across universities, but we don't have any inter-university competition in mediation as on date. Something like we have the moot competitions could be introduced, and best video in mediation, best talk in mediation, best mediator, best case in mediation, and outstanding mediator. These are all avenues in which to encourage students. Now, other than this, sponsorship and collaboration by business and outside bodies gives both funding and publicity and better participation by all. For this, encourage collaboration with international bodies promoting mediation education. For instance, we have the International Alternate Dispute Resolution Academy, the INADR, which promotes mediation education across the world. This institution, organization, had collaborated with our National Law School in Bhopal in the conduct of mediation competition last year. So more such initiatives need to be put in place and encouraged. And then we also have the peace consulting in Singapore, wherein the mediation for resolving small everyday problems is encouraged amongst the high school students. So this is all about my thinking process, and it's been a long talk. I think I've spoken for almost more than 1 hour, and thank you so much for your patience.
Thank you, Bharati. Very nice, extensive thing, but it's not going to end now. We're going to still have questions. So we're going to I have questions for sure. Of course, on the last one, on you said about inter-university mediation competitions, there are a lot of them happening. Whether that's at least the awareness because of that is happening. The way they're conducted, obviously, they're not real life situations. So obviously, are they understanding of mediation as such, if it is going out correctly or not, we can always debate that. but that part of it. But one thing you did speak about was about some kind of a body which is reporting to the Chief Justice of India. I don't understand why we are at all even involving the judiciary in mediation. It's like on a crossroad. I want to go right path is the should be the mediation path, and the left path or the wrong path should be the litigation path. They're totally diametrically opposite paths. Why are we connecting the two? Why should it be associated in people's mind also that there is some connection with litigation and mediation? Because the whole concept is totally opposite to each other in every way. There is no connection at all. So why should, first of all, the judiciary be involved in it? They are not being able to do their job. What their job is, please do that. You put a notice outside the court saying we deny justice because justice delayed is justice denied. You do all that. You correct things within yourself. Get used in India, the 43 million cases. Get out of there. What I mean, keeping someone in court for 20 years and then you can't do that, and now we want to do something about mediation. What are you developing the profession? You want to give it free in courts, almost free in courts. That person who's practicing in the court or he's doing the mediation, is he looking at it in so many years? 2005 we got the first mediation center. Are they looking at that as a profession? Are they practicing only as a mediator in all these years? So there is a fundamental issue there. So I am saying that as mediation, if it has to develop as a any kind of primary, I'm saying it should be primary because this is what we've heard in our discussions earlier. It should be the primary way. Even I mean, to come close to it also is going to become difficult. So I just feel that why are we so hung up in this colonial aspect of courts, and courts will give justice. Where are the justice? Where is the justice? I mean, ask the person, one person also who has gone through that in his life. What is the experience with the judiciary? So I'm just saying that yes, it is a colonial hangover we have, and we have to talk about courts should come in every dispute. We have to involve the court for some reason in whatever way, even if it comes to mediations. I think we have to relook that part definitely and very fast, because they have a self-interest. Someone who has a self-interest, I won't even say vested interest, I say self-interest. If they have a self-interest in taking care of backlog, then those people, the way they are going to give suggestions to the government to come out with a draft law is going to be different. You don't give, if you have a vested interest or self-interest in something, how are you giving a suggestion? What are you going to say? All those things that you will say only will be for your interest. Yes, you have a good lobbying power with the government, but should you misuse it? So I think they should stay away from it and should tell people that, look, we can't do what we are supposed to do. Why don't you look at some other options? And mediation is a good option. Go there. Find your way out. It is part of, even the Chief Justice in that Singapore summit talks about Panchayat, about Krishna, and whether Krishna did mediation or not, we'll have to go into that. That's another debate. Whether was he negotiating or was he just putting a proposal or whatever, that we can look at that. So I mean, there are a lot of things to be debated on that end, but I'm just saying that the mediation law, if it has to be, you're looking at the mediation law, what according to you today, this legal structure, because you didn't speak about the current legal structure, so let's just talk about the conciliation which is available to us. So what are the changes that you would want in that, so that it can, I mean, would you have an issue with the fact that there is a provision for conciliation?
Provision for conciliation in that it is advisory, isn't it?
No, it is totally it is. He just can suggest, can only
Advisory.
suggest, not it's a proper, it's a mediation. Because I tell you what has happened is that UNCITRAL had in there in 1990, when we got 1996, at that time UNCITRAL was using the word conciliation. So what we have is actually mediation, but UNCITRAL was using the word conciliation. Now today in the 2018 model law, they very well clarified this. They have said that we were using that word earlier, but because in the world, the word mediation has been used, so now we are saying that we are using the word mediation. They are both the same thing. They have said it themselves. I mean, we are still got this some issue that we will keep saying that there is no law in mediation in India. We need a law in mediation. Why confuse people? I mean, just saying that you have, okay, you might,
yeah. Just a moment. I think in conciliation, the mediator has an advisory role, isn't it?
look, I won't use the word advisory because advising is a different concept. It is a matter of suggestion. You can suggest what you should do, but which is the concept in mediation in general. You may suggest, but it
Yeah.
is not you have to suggest.
Yeah, mediation, what we can do is often and many times what happens is people may not be aware of the options.
So what I'm going to do right now, first what I do is I'll just take you through the model law that UNCITRAL has given
Yeah.
and what they have said about mediation. If you just read this mediation definition that they've given, so this is exactly the similar way that Singapore Convention talks about it. So that is how wide it is. Whether referred to by the expression mediation, conciliation, or an expression of similar import, it's the same thing. Now let us look at the bottom at the footnote. Footnote is very important. This footnote here, number 2 here. If you read the footnote, if you have a look at that.
Interchangeable.
So, yes, we picked up the draft, the model law that UNCITRAL had made. We called it conciliation because they were calling it conciliation. So today we have a law on mediation. Does our law on does conciliation fit into this definition of mediation? Yes, it fits in totally. Whether it fits into the definition of mediation in the Singapore Convention, totally. There is no doubt about it. So what does the Singapore Convention say? Let's have a look at the Singapore Convention. This is, you can read it from here and I'll show you the Singapore Convention. So point is that we have a law on mediation in our country. What are the issues that we have in that law? What do we need in terms of ratification of the Singapore Convention? What is it that is required in addition to what we have? The fact is, in this conciliation, the provisions that we have, the settlement agreement becomes as good as an arbitral award by consent, which is as good as a court decree. So our route is through that arbitration. Under section 34, you have an option of setting aside an arbitral award. So those criteria can apply. It is under section 30, a consent award is as good as a consent award. So section 34 would apply to that. But in the Singapore Convention, we want to go directly to a court decree. So whatever criteria has been mentioned in the Singapore Convention, as these are the criteria if you don't want to, if the court wants to refuse enforcement. So what is the criteria mentioned? You can put those criteria directly and let the settlement agreement become directly a court decree. But we have the entire framework there. It is totally flexible. I can show you from the act, the way it is worded there, exactly what you said about online or everything is taken care of. Let me show you that. I mean, because the point is that there is so much on this issue that keeps coming. Just have a look at this. Very nicely put. I mean, it can't be better. Consider shall be guided by principle of objectivity, fairness, and justice, giving consideration to all this. This is the way it has to be done. And this is the way traditionally it is done. This is the way you have to do it today. There is nothing that more is required of that. Now, the number 3, may conduct the conciliation in such a manner as he considers appropriate. Where is the problem? You can do it online. You don't want to do it online. Anything that you want to do, the wishes of the party, because finally the parties have to decide. So what is it? What is lacking in this? I mean, I see that the framework is totally there. Now, there is no regulation of the person who has to be a mediator. Definitely should not be there. The parties have to trust the person. You can't say, I trust so and so, but the law is the one who's restraining me from appointing this one person. Why should a law restrain me? Who are you to restrain me to find the two people themselves want to get together and resolve their dispute? Why do we want to control it? The government did not want to control it when we got the law. Someone somewhere understands the larger vision of the whole thing, and hopefully our government today also will understand this. I mean, the point is there is pressure. If the Chief Justice of India wants to set up a committee, and who are in the committee, the judiciary has no connection with mediation. The senior counsels.
Just a moment.
Yeah.
Maybe this has to be signed by a senior professional, maybe even the President of India.
No, that is the law will go through the law will go through the legislature. No, the law has to go through the legislature. These are just recommendations they can give. Yeah, exactly. So the point is that you are the Chief Justice of India. You are setting up a committee. You are putting something to the government. Aren't you misusing that power in a way that you have? Aren't you
Yeah,
saying that you must? Why are you saying
yeah, in
what you're
my
saying?
favor.
Why are
In
you
my
saying it?
favor.
Yeah, because you have a self-interest. You are not connected. You are not concerned with developing the profession. You are not want. I mean, you people don't want to come to court. They should not come to court. But why are they coming to court? You should be able to put, because you haven't told them. Don't they know? I mean, shouldn't they know that you are not giving them justice? You're denying justice by delaying it. Shouldn't they?
Yeah,
Shouldn't you be
very
talking
true,
about that
very
all the
true,
time?
very true.
That's the only thing you
Very,
should be talking about. But
uh,
who else are in the committee? If you have a person who is running the mediation center in this, there are lawyers who are running it. Lawyers are senior counsels. How much do they charge for their fees in the court? And what is the amount paid to the mediator? And in the civil procedure code, the requirement for a lawyer is 10 years of experience. 10 years of experience. Jawad was talking about Chennai in Madras High Court. That is, he gets whatever happy. He gets 7,000 rupees. How much is that? $100 for the entire thing. Whatever he has to have 20 sessions, whatever. What is it for a person of that kind of experience? He's of course got lots of more experience. So I think fundamental issue is that, first of all, can we get it out of the court system? This whole mandatory and anything, all that is lying, all the cases lying in court. You want to do what you want to do for the moment. I can't say that anything about that. Obviously, they should go out of the court system. But if, like you was correctly saying, that the awareness has to be created and people should be able to understand the benefits of it, and then they should go into private mediation or conciliation as we have, because even the civil procedure code says that the option of the parties to go for arbitration, conciliation, lok adalat, or mediation, they've given those options there. So what are the differences in that option? The Supreme Court definitely has clarified that. But the point is, under conciliation, any case they go under the act. So if they are going under the act and they reach a settlement agreement, it is anyway as good as a court decree. So just finish off the whole thing there. And if the settlement agreement doesn't happen, if they want to come back to court, that give them the option if they have to do that. But the Supreme Court in that AFCON's judgment still said that even after that they should come to the court. You court wants to pass a decree. I'm okay with that. I mean, if they want to pass a decree, I can't say the parties also might prefer that, if because of the fact that conciliation hasn't been discussed so much. The parties don't know whether it is actually as a good as a court decree or not. Those are the judgments we need from the Supreme Court on this aspect of it. Look, conciliation by its
yeah, 1 minute. So maybe all what I stated should be covered in the Mediation Act.
which is already there. We
No,
already
no.
have that. We have the Mediation Act.
Act.
It is called conciliation because of the fact, like I told you, because it was called conciliation at that time. Change the word, call it mediation. What is the problem? How much time does it take for the legislature to change the word? That we are going to call it mediation because now we have to, because UNCITRAL has clarified also, and we also feel that mediation is the word being used around the world. Call it that. Now, how does it change anything? I'm saying everything that is in the part of the conciliation, if you had a look at it, it is such a nicely drafted legislation that you don't need to change anything. I'll take you through that. I mean, why I'm taking you through that is because the fact is, I don't think people even read this act. No one reads it because no one has told them that is such a good legislation is lying there. So let's just have a look at it. What does it say? Let's have a look. I mean, I have enough time on this issue because I feel that this is where the problem lies. We have everything going for us. We should just, wherever you read the word conciliation, read it as mediation, nothing else. Just read it as mediation. So basically, you can go for mediation as arising on a legal relationship, contractual or not, no issue. So it covers everything that you want to do. Commencement, exactly, one party inviting the other party, waiting for that entire procedure is there. So perfect. What else you want? And then number of conciliators, they said they can be up to 3. Not a problem. Let's just keep it at that. Then we have everything, appointment of conciliator, how it has to be done. They can take assistance of a institution or person, that's up to them. But now, interestingly, if you look at the last proviso here, we had such a long-term vision on this. And with respect to a sole or third person, that shall take into account the advisability of appointing a conciliator of a nationality other than the nationalities of the party. Other than the nationalities of the party, we were already looking at maybe a cross-border situation.
Before the SCM.
Yeah, exactly. 1996. I mean, not even, I mean, this is something available to us since then. We're far ahead of the times, but no one wants to today also acknowledge it. Today also they're saying we don't have a,
Just a moment. Why is this not publicized?
because there are vested interests. Who will do it? The legal profession is not going to do it. Why would they want
For
to?
instance, I didn't know till now.
Exactly. That's what I'm saying. We have the best law in the world. I'm not even saying in India, we have the best law in the world. Everything is provided for. Just change the word mediation to mediation, conciliator to conciliator to mediation, conciliation to mediation, and conciliator to mediator. You find everything that you need. Everything. Confidentiality is protected. Without prejudice is protected. What else do you want? I just showed you the role. Administrative assistants, their wish, they want to take that. The communication between the parties. It can be joint session or caucus, everything. We use the word caucus now, private session, everything there. The conciliator decides where to have the meetings. Unless the parties have agreed. So party self-determination, the most important thing covered. Look at this. He shall disclose the substance. Proviso.
Very important law. I'd like you to speak on this in one of the forums.
Not even required. I mean, so self-explanatory, so self-explanatory. It is put in such simple language, even you can send it out to a village and they will understand what is written there. Not no legal language. Someone understood what the India needed, but for some reason the judiciary doesn't talk about it, the lawyers don't talk about it. What else? I mean, come off it. I mean, if you have everything going for you, why are you even talking about some future, something which you are only going to spoil the situation? Suggestions can be given, right? No problem. If you want to give, you don't have to give it. So he gives a certain whatever based on that. Then it can be, you can go into it, you can keep refining it. Then they enter into a settlement agreement. Perfect. Settlement agreement done. Status, most important. It is as good as an arbiter aboard on agreed terms, which obviously under section 30, which is as good as a court degree. Confidentiality, especially. So what if you have to leave? If you're running short of time, we can always finish
actually,
I want to show, yeah, no, not a problem. I'm just showing you that confidentiality is specifically protected. Even the US doesn't have that kind of situation. Yeah, please.
Leela. Don't mind it.
No, not at all. It's perfectly all right. Hello. What's her name?
Leela.
Neela. Hi, Neela. So we have to train her also on the conciliation aspect, because they are the kids are going to start. They are the ones we need to take. So this is very important. Confidentiality. I mean, in the US, they are struggling with it. In 40 years, they're still struggling with confidentiality. We have it in 1996. Okay, but when does the conciliation come to an end? Perfectly all right. Settlement agreement signs or the parties agree, whatever. I mean, not an issue. So you shall not initiate these proceedings unless they are necessary for preserving the rights. Not a problem. I mean, basically, all these things cost not a problem. Obviously, they decide.
Fix the costs of conciliation.
Yeah, that's between the parties how they want to do it. They can get whoever they have to get, whatever cost, then they bear it. They can decide how they want to bear it. The cost shall be borne equally by the parties. or they can provide for something else. That's totally, flexibility is totally there. I mean, not a problem at all. Okay, the deposit to that, so that
Which
just
is,
safeguard
1
whatever
minute,
amount.
which is this act?
It is under the Arbitration and Conciliation Act. There's a part on conciliation. Part 3 of the Act is on.
Okay.
This is very important. Okay, which is what today even the UNCITRAL and the model law talking about the mediator not being an arbitrator. Which is what I mean. We have that today, which is what some people might have a problem with because they won't be appointed as arbitrators. Maybe conciliators shall not be presented by the parties as a witness.
Means in the case of arbitral award and court judgment.
But the point is that a person who's a mediator, in this case we call it conciliator, is party to a lot of information. So you can't expect the same person to be an arbitrator in the same case. It won't be correct. So if we have that, now look at this part. This is very important. The conciliator shall not be presented by the parties as a witness. Isn't that very important? So it is protected. So the conciliator doesn't have the problem there. This is very important. Parties shall not rely on or introduce as evidence in arbitral or judicial proceeding whether or not such proceeding relate to the dispute that is the subject of the conciliation proceedings. Without prejudice aspect is also protected here. What else do you want from a law? I'm just asking whoever is talking about drafting a law, what else do you want from a law? You want to regulate it, you want to create a mediation council of India so you can be part of it. What is the reason for you to talk about it? That's it.
There's a lot of talk about Mediation Act now.
That's what I'm saying. We have the act. We have to use the word mediation. Okay, today what you do, Bharati, have a look at this act. Just wherever you read it, what you do is with a pen, just mark out conciliation and call it mediation, and conciliator call that mediator, and then read the act. What do you find all should be there? Look, I am never going to be in favor of any accreditation or certification because parties are the best judge. You can put out as you can have whatever you have, institutions have panels, whatever. Let the parties choose. I mean, that's up to you. You can't regulate it under the law. Parties have to decide for themselves. You find a way. You can tell parties, no, this mediator is better than that mediator. You can go on. But is that, I mean, is that the way it should be for in the law to protect that, to protect people from the fact to them going to someone else? I mean, I just feel that we've got something going, some thought process. We're not understanding the scale. 1.3 billion people in this country. Who are you going to be? Are you going to be, how many mediators do you need? Maybe 1 million mediators? At least, I'm saying 1 million mediators. Are you going to be able to train? Who are the trainers? Who's going to train them? Anyone who can train anyone. First of all, do they need training? They have the natural ability. The parties identify them. They are going to use them. They're already using them. If today only 18 million cases go into courts today in India, there must be something right we are doing that way. Because the government is such a big litigant, if government is not such a litigant, so things are not solved by the matter. So the backlog, which is a problem. So take care of the backlog. We have a full system somewhere. We have a large rural population. Maybe we have to go back to that, see villages and all what is happening there, because it's all there. Some structure is already there. So there's a lot. I think we'll discuss it again maybe some other time.
Yeah, I think there is a requirement to discuss this law.
Yeah.
Yeah.
Absolutely.
Yeah, please do.
Perfect.
In the context of today's talk.
Yeah.
And, especially in the context of Singapore Convention.
Exactly.
Yeah.
Perfect. We'll do that. But I have to leave. I can understand. Thank you very much, Bharati. And it was really nice. Will take us through a lot of things. And if Giovanni wants to say thank you, Giovanni, if you want to just thank Bharati for
many thanks. First of all, the problem conciliation mediation. Until 2010, we used only the term conciliation. Later on, a law came in force, and mediation is the proceeding, conciliation is the result. And now all we use mediation first. Second, Singapore Convention on Mediation. I think that there are two main basic problems. The method of mediation that you underlined, and the certified signature on the on the internet path. These are the two main problems. Later on, all the others will be solved just by training. And many thanks for all your speech, very interesting. And I really hope to be in contact with you also in the future. If you can send me also your email address, I will be very pleased.
Please
Many
connect
thanks.
with also connect with her on LinkedIn.
And best compliments for the eyes of your daughter.
And anyway, you can connect with each other. Everyone's LinkedIn profile and Facebook is lying on my website. Please connect with each other there. So